So thank you once again for joining. We're now up to, I think, 149 participants, which is a very good number. Thank you. Can I express my particular thanks to Jim Hirschmann and Delphine Avondo and Niamh Jarvis for organising this conference today. In September 2025, the Law Commission laid before Parliament the report about which we will speak today. It is the Commission's report on disabled children's social care and was commissioned by the Department of Education. The report itself runs to 220 pages and contains 40 recommendations. There is a published summary which runs to 29 pages, so you may want to look at that first if you do some further reading. Those of us who practice in public law and family law generally may not feel accustomed to dealing with the dense and complex statutory code that relates to children with disabilities. As a consequence, I wonder whether we don't sometimes miss points that relate to the statutory support that should be offered to children with disabilities whose parents look to us for help. Those who engage in the field of social care and education law more broadly will, of course, regard this report as essential to the work that they do. Well, here today are 6 experts from 3 PB barristers to help us through that complex and important area of law and guide us to an understanding of the long report. I'm going to introduce the speakers in turn, and I'm going to ask speakers, please, to turn off their cameras and microphones, except when they're speaking. Our first speaker is Jim Hirschmann, who will speak about recommendations 1 to 4. Jim specialises in adult social care, child social care, education law, and associated public law challenges, and also is the chief organiser of this conference. And so, as I've said before, we are deeply indebted to you. Jim, thank you. Over to you.
Thank you very much, Stephen, and good morning to you all. Just in terms of the agenda, you'll have it here, and the slides will be shared in due course, so don't feel a need to take notes of anything that's on the slides. I am going to be dealing with chapters 1 to 4 of the report, and you can see them outlined on the screen here. But I'm going to dive straight into the recommendations themselves. So chapter 1 sets the background for this report. And I think there's 2 important parts of disabled children's social care law that should get special mention today and get special mention within the report. The first is the Chronically Sick and Disabled Persons Act from 1970. And as the report notes, it created for the first time a duty to meet the needs of disabled children and adults. The report by the Law Commission quoted Alf Morris MP, describing him as the driving force behind the Act and the first minister for disabled people. He said, "We were determined to make mandatory what was then permissive, and in doing so ensure that everything humanely possible is done to normalise the lives of the long-term sick and disabled." The second important act is the Children Act 1989, with which most listeners may be more familiar. And that was meant to bring the scattered legal provisions relating to services for disabled children and children in need of protection from harm under the umbrella of a general power to provide services to promote the care and upbringing of children within their families. And in the words of Baroness Hale, one of the architects of that act, the hope was that all would be seen simply as children in need of help. So that's the backdrop for the legal regime that the Law Commission was looking at. And the first recommendation that they make is to expand the Children Act 1989. Initially, they had in mind to create a new, distinct legal mechanism for disabled children. but they were persuaded after consultation that it would be better to keep it under the Children Act 1989 because it's more holistic. The concern was by siphoning off disabled children into a different regime, you might not get the same holistic treatment of children. You might get less identification of their needs, and their needs would then not be addressed as effectively by public authorities. So what's envisaged, you can see there at 2.15, disabled children will remain within the scope of Section 17 of the Children Act 1989, and a disabled child should continue to be classed as a child in need. And what we can expect, therefore, is consideration of expanding Section 17 of the Children Act 1989. That will be accompanied with a single statutory bit of guidance, which takes me to recommendation 2. The statutory guidance and local authorities need to follow this unless there's a good reason not to. For those of you interested in the mechanism of it, the proposal is for it to be issued under Section 7 of the Local Authorities Social Services Act 1970, which says that local authorities should act under the direction of the Secretary of State. And case law establishes that that must be followed unless there is a good reason not to. So that will be an exciting framework where professionals working in this area will have access to one guide that should set out everything material in terms of law in this complicated area. Recommendation 3 was how to tackle the definition of disability. And there was much discussion of the way it could be done. There was general acceptance that the wording used in the 1970 Act is somewhat outdated. And ultimately, the Commission aligned on using the definition from the Equality Act 2010, which, whilst imperfect, is more in keeping with more modern legislation, such as, for instance, the Children and Families Act 2014. So at 3.21, you'll see the sort of definition of disability as applied in the Equality Act. And there were a few niches, if you like, which are important to bear in mind. So first of all, when you are looking at a child under the age of 6 years old, it might be hard to identify whether it has a substantial long-term adverse effect on their ability to carry out normal day-to-day activities, because of course a young child's day-to-day activities are different to an adult or an older child. So you should treat it a disability for someone under the age of 6 as an impairment if it would have a great impairment for a person over 6.
Thanks, Jim. We're up to 5 minutes.
Thank you very much, Stephen, which means I've got 2 minutes left. Those of you who deal with the Equality Act will be aware of the Equality Act Disability Regulations 2010, which try to exclude addictions, certain addictions, and certain other conditions from being an impairment, which includes things like a tendency to set fires, a tendency to steal. That there are others, but look at those 2 regulations if you want the detail. But those exclusions are not going to apply here. So the Law Commission has quite strongly recommended that disability should just be the criteria at 3.21 of this slide. The Law Commission was at pains, as you can see from 3.24, to be clear that a recognised medical diagnosis is not necessary to satisfy a definition of disability. And therefore, the definition can encompass a diverse range of conditions that can affect a child's ability to perform daily activities and address the particular circumstances of disabled children in adoptive families. In short, the Law Commission, I think, was echoing Lady Hale's view that all children in need will have their needs met. Finally, just in terms of what the statutory framework might look like, recommendation 4 was to give a checklist for decision makers. So first, an overarching principle that the best interest of a child should be a primary consideration, not the primary consideration, a primary consideration. So that puts the recommendation in line with sort of the international framework for protection of children. 2, a set of considerations to which decision makers should have regard to. Those of you who practice in court of protection, mental capacity law, will be aware of the framework of the Mental Capacity Act 2005, and it'll be mirroring that. And at 4.22, you'll see the 10 criteria to which regard is going to be had. So that is it in a whistle-stop tour, but I hope that's helpful, and it's been a lovely pleasure to speak to you all this morning.
Thank you very much, Jim. And as people will realise, that there's an awful lot to get through, so forgive me for being public enemy number 1 and interrupting speakers as we agreed I would. But that's really helpful, Jim. Thank you. And can we now please call upon Jennifer Kotilaine to help us with recommendations 5 to 12 of the report. Jennifer is a barrister called in 2011, whose practice is split between public law children proceedings and proceedings in the Court of Protection. Jennifer, over to you. Thank you.
Thank you. There are quite a few recommendations in Chapter 5, and what I have done in the interest of keeping my section of this presentation to be as brief as the other sections is to talk about these recommendations thematically. I do recommend that you look at the report to see the specific recommendations as they have been laid out. Now, the issue in Chapter 5 is about how a child's needs should be addressed. And there are 2 main sections in this chapter. One is about how an assessment should be obtained. And then the second is about the process and content of assessments. The difficulty is that the duty to assess the social care needs of a disabled child is, in the view of the Law Commission, currently implied. It's not express, and it's not clear from reading the legislation alone that a duty to do such an assessment actually exists. And so the Law Commission takes the view and is recommending that there would be a single express duty to assess social care needs of disabled children. And the purpose of that assessment would be to identify a child's needs and then decide whether or not a local authority can or should use its powers or its duties to meet those needs. And that is something that will be covered later on in this presentation about powers and duties in Chapter 7. The assessment would be, therefore, the gateway to all services that would be available to the child. Next slide, please. So this is the majority of consultees who responded to the Law Commission's consultation were in favor of having a single express duty. It seems a bit hard to argue against it, but there are considerable concerns among those who have responded to the consultation about what the threshold would be for such an assessment. And the current threshold is whether or not a child appears to have, or sort of when a child appears to have a disability. So it is, if a child appears to have some disability, then the duty to assess is triggered. But the Law Commission's view is that the more relevant question is whether, because of that disability, a child may have need for care and support. And that, I don't have time now to go into it, but if any of you are interested in looking at Section 9(1) of the Care Act, you will see a great similarity between the wording that's proposed by the Law Commission and the wording that already exists in law in the Care Act. So what happens is, what is proposed to happen is that although a diagnosis is not necessary to meet the threshold for assessment, there are other aspects that need to be considered, including family support. This would not mean that there would be no provision that would be provided to children, but family support is very important, and it is a part of any assessment that would be carried out. There is also a question about whether or not a child is in fact disabled, and that, of course, would be an essential part of any assessment process. If we could just move to the next slide, please. So as Jim has already said, it's clear that disabled children would remain children in need pursuant to Section 17, and that what is effectively being proposed by the Law Commission is that the rights or entitlements of children in need who are SIN children due to disability should be set out either in a part or a schedule of the Children Act. So there would be an expansion of Section 17. Moving to the next slide. So what happens then with these assessments? Well, first of all, it's clear that that the Law Commission, I mean, it can't make firm recommendations on any of this. So, but it is trying to steer lawmakers into perhaps thinking more creatively when they do come up with legislation. One is that there should be a rebuttable presumption that assessments should be combined unless there is not any good reason to do so. There is stuff to say about early help and family help. I don't have time to do that now. I'm looking at my stopwatch.
2 minutes.
2 minutes to go. So I'd welcome a question on that. But essentially, the early help and family help schemes that do exist are not, in the view of the Law Commission on their own, sufficient to meet the duty to assess that is being proposed by the Law Commission. So this would be a different kind of assessment. If we can move to the next slide. So, of course, having a duty to assess children who may be disabled or may appear to be disabled is a significant burden on local authorities. And so what the Law Commission is proposing is that assessments be proportionate and appropriate. Proportionate, by which they mean that a proportionate assessment is one that is neither more complicated nor onerous than it needs to be. And that is a question that deals with really the length, the detail, and the intrusiveness of an assessment. And then the appropriateness of an assessment is one which is conducted in a way that works best for the child. To have, for example, a telephone consultation with a child who is nonverbal, that would be inappropriate. There is quite a lot more to say. I'm very mindful of the time. I can say that the Law Commission is proposing that there would be quite significant statutory guidance in respect of proportionality and appropriateness, but that this will no doubt be an area that is ripe for legal clarification when such laws are enacted. Many thanks, Stephen.
Jennifer, thank you very much. And there'll be there are already some interesting questions that people are putting in relation to how this might be funded. But now we're going to have the privilege of hearing from John Friel in relation to recommendations 13 to 22 of the report. John is a highly experienced barrister practicing in this field of law, having succeeded in some of the landmark cases within it. So, John, thank you for joining us, and over to you, please.
What I've done is given a quick view of the chapters 6 to 8 and then looked at the recommendations. I'm going to do a quick précis, and Jim, if you'd move to the recommendations, we'll shift through them because time is very limited, as everybody is aware. The chapters, first of all, cover the role of carers and the role of siblings. Secondly, they cover the criteria that exist at the present moment and make recommendations about how that should change because they're basically chaotic. And thirdly, they look at services to be provided and try and combine those. They also look at the legislation, and they come to the conclusion that the 1970 Act, Alf Morris's Act, is very outdated. And if you deal with it in practical terms, which I certainly do, there are terms in it like wireless access to libraries, but it ignores the developments of IT. Equally, the Act was brought in when disability was very different. Morris was deaf, and it was very much physical disability. And at the time, the National Assistance Act was the act that defined disability itself. So it's plainly outdated. And things have moved on as well since the Children Act. So what are the recommendations? Well, I'm going to run over them very quickly, and I'm not going to go through each one. I'm going to give you a flavour of them. First of all, in relation to both siblings and relation to carers, the guidance and the statutory criteria should be widened to ensure that carers, whether they're parental carers or partner carers or carers in charge of the child through various means under the Children Act, are in fact part of the assessment process and are not ignored. And siblings who are definitely ignored on most occasions are assessed, thought of as children in need, and looked at very carefully. In relation to the criteria, each local authority at the moment has criteria, and most criteria are designed to eliminate all but profound and severe, which was never the intention of legislation. So what the Law Commission is saying is that, first of all, the criteria should be unified. Jim's already referred to the definition in the Equality Act, but also they've pointed out that each local authority's criteria differs, so nobody knows what's going on. And if you move to one area or another, you may find you qualify in one area and then it's all taken away from you in another. So the recommendation here of real value is that the criteria under the Children Act should match the regulations for the 2014 Care Act. In other words, the Care and Support Eligibility Criteria Regulations, which set out some basically 8 characteristics that qualify you for support. But they also say, even then, if you don't fit in and you're a child in need, there should be an exceptional category so that your needs are met if it's appropriate to do so. So they're equating an adult care criteria, which are much better and rigid, with Children Act criteria, which are loose, random, and ineffective. The last issue is what sort of services should be provided. And the services they are looking at are very wide, but they are particularly emphasizing respite, whether at home or in the community, particularly in the community. They're emphasizing support for the more disabled child within the home, such as support for the parents with dressing or community access. They're emphasizing the replacement of phraseology in the Chronically Sick and Disabled Persons Act with phrases such as library and wider and wireless access and provision of a phone, with much more wider criteria of goods and services and IT. They're advising that the services should include counselling and other advisory services as well. Now, that isn't something which is normally done by social services at the moment, and it is a new criteria. They're also advising specialist equipment, which was in the Chronically Sick and Disabled Persons Act. Assistance with travel and travel arrangements. There is actually a requirement under the Chronically Sick and Disabled Persons Act to provide holidays, but that would be taken into account in educational or leisure activities now. But travel arrangements remain for those beyond the age of 25 particularly very difficult. And the other point is that they actively advise advocacy as well as advice, which is completely missing from the current services. So
a minute and a half, please, John. Thanks.
Minute and a half. So putting it shortly, it's a comprehensive revamp of the services that can be provided, the criteria on which the services are based, and lastly, making sure that those who are on the margins or ignored, namely carers and siblings, are brought in to the centre and are equally important as the individual child with disability because of the way in which their life chances interact. I think I'm under the 7 minutes, but I'm going to stop now and allow it to move on. Somebody's going to need those extra few seconds.
John, that's fantastic. Thank you for that. We're now going to move to ask Katherine Anderson to speak in relation to recommendations 23 to 30. Katherine is an education and employment law specialist with particular expertise relating to special educational needs and disability. She's the author of a practical guide on special educational needs and education health care plans. So, Katherine, thank you. Over to you.
Good morning, everybody. Chapters 9 to 11, first of all, 9 deals with the methods of providing services. 10 looks at the plan to meet the needs of a disabled child, and 11 looks at decision making by disabled children. So if we go on chapter 9, this has a number of recommendations. But first of all, what chapter 9 does is it sets out that there are 3 main ways that local authorities can secure the provision of social care for a disabled child or their family. Firstly, by providing services directly. Secondly, by arranging for someone else to provide the service. And thirdly, by direct payments of money to the parent or carer of the disabled child or the child themselves if they're old enough, so that they can purchase the service for themselves. And that direct payment method can only be used where the parent consents or the child consents if they are 16 or 17. And the Law Commission has suggested that statutory guidance could clarify that consent process. But more importantly, direct payments are only made at a rate that the local authority estimates as the reasonable cost of securing the service. If we go back a slide, because therein lies the key problem. In actual fact, the Commission sets out, direct payments aren't always sufficient to secure the services. And so the Commission identified that also, even if they are sufficient in financial terms, there's a general shortage of carers. Local authorities don't always review the provision of direct payments, so they don't always notice when problems arise. Or if parents raise problems, that doesn't always result in local authorities assuming responsibility to provide the service by a different method. And also, purchasing a service with direct payments can involve parents and carers taking on complex responsibilities. For example, becoming an employer, having to pay and administer national insurance and holiday pay, sick pay and employers' liability insurance and VAT and so on. So the Law Commission has recommended, firstly, that the direct payment regime should be adapted so that the amount of the payment is sufficient to cover the actual cost of the provision necessary to meet the disabled child's assessed social care needs. Would that mean a need to increase funding? Is there a risk that the proposal would distort the market? Well, no, the Law Commission thinks, no, it wouldn't if its further recommendations adopted that local authorities shouldn't be required to make a direct payment if that would have an adverse impact on other services which the LA provides or arranges for disabled children, or if securing the proposed agreed provision by direct payments would not be an efficient use of the authority's resources. Now, this would require the local authority to think about whether the direct payment method is viable before commencing it, which is preferable, I think, to it being left to parents and carers to raise issues after things have gone wrong. But the Law Commission also recommends that the local authority should be required to keep direct payments under review, and that the review process should be aligned with the review of a disabled child's care plan. And that comes in at chapter 10. Now, personal budgets, the Law Commission also makes a recommendation there that there should be a right to a personal budget, like there is in the Special Educational Needs and Disability, the SEND system. A personal budget's an amount of money identified by the local authority to deliver provision for an individual child or their family, where the parent or child's involved in securing that provision, child if they're old enough. The family can receive that money by direct payments, but alternatively, it can be held and managed by the local authority or a third party, and the family would have a say in how the money is spent. Now, the Law Commission admitted that the benefits of personal budgets aren't exactly clear, and there's little research in that area, but a right to a personal budget, it feels, would benefit families who want some choice and autonomy around how they receive services, but don't want the administrative burden associated with direct payments. It proposes that there should be exceptions to the right to a personal budget, like there are in the SEND framework. It recommends that a local authority should be able to refuse a personal budget if it's paid an aggregate sum for a service for a group of children, and disaggregating the cost of providing that service for an individual child would have an adverse impact on that, and also where it wouldn't be an efficient use of resources.
2 minutes, please.
Okay, so on to chapter 10, I'll plan to meet the needs of a disabled child. So the Commission noted evidence that children in need plans generally aren't consistently implemented, and they're poorly monitored and they're difficult to evaluate for effectiveness. Its terms of reference, however, only relate to disabled children. It points out that the courts have interpreted legislation to mean that disabled children are entitled to a plan, i.e. a document that sets out what services are to be provided for them and their family, and where, when, how and by whom the services are to be provided. Government guidance also says so, but the legislation doesn't say so expressly, and the Commission recommends that the legislation should say so expressly, that it should say also how often a plan should be reviewed. It looked at how often a plan should be reviewed and suggested that a more flexible approach to the timing of reviews would be most appropriate, but didn't consult on specific options or make specific recommendations there. It decided against making a recommendation that there should be a statutory duty to secure the provision in a plan. It made recommendations that there should be statutory guidance on the contents of plans. It considered that whether there should be secondary legislation for that, but concluded that guidance is the more appropriate vehicle in the interests of flexibility. It also looked at whether the plan to meet the social care needs of a disabled child should be combined with other plans for the child, such as their EHC plans, and concluded that plans should be combined where practical and appropriate to do so. So local authorities should have some discretion there, and again recommended statutory guidance to assist in that regard. Then on to chapter 11 about decision making by disabled children. In practice, it can be difficult to secure the participation of disabled children in decisions which affect them, as there's a lack of clarity and consistency in relation to which decisions disabled children can take for themselves and the legal test for determining whether a child has the ability to make that decision. So the Law Commission proposes that the law should set out expressly which decisions and actions disabled children should be able to make, requesting assessments of their needs, making representations in the course of that assessment, representations about the content of plans, opting out of advocacy support where there's a duty to provide that support, requesting that services are provided by way of direct payments, and making use of relevant remedies. And it considered what sorts of tests should be applied in relation to whether children have that ability to make those decisions. It concluded that the local authorities should be applying an ability-based test rather than age-based, because age isn't always a reliable approximation for ability, and looked at different tests for those aged 16 and 17, a capacity test in the Mental Capacity Act being appropriate, and providing some consistency and clarity. And for children under the age of 16, a test based on the functional element of the capacity test, that the local authority should regard the child as able to make the decision if they can understand, retain, use and weigh the relevant information and communicate their decision. It felt...
Thank you.
Yeah.
And if we could just show the slide in relation to recommendation 30, please.
Yes, so
Jim.
finally that the local authority... the recommendation that children are not permitted to opt out. There's a risk of abuse or neglect.
Okay.
Thank you.
Thank you, Katherine. And I'm sorry that we're so tight on time, but we're now going to hear from Liz Adams in relation to recommendations 31 to 36. I realise there's an awful lot to go through, and if people want to send in questions, we'll try to deal with them after the conference. Liz practices from 3PB Barristers in Family and Education Law. She appears regularly in the SEND Tribunal appeals. In her family practice, she's instructed in public and private children matters, financial remedy and injunction proceedings, often where there are issues involving education, disability, special educational needs, health and social care provisions. Liz, over to you. Thank you.
Thank you, Stephen. If we could have the bullet points on the slide, please. This is a very quick overview of recommendations 31 to 36. And just as a brief warning for you all, the next few slides do contain images. They are AI generated, they are not real people, simply intended to add a bit of life to the vision that the report is setting out. And I have also set out the recommendations on these slides in wording that is not always the exact wording from the report, because I have condensed it for this presentation. If we could have next slide. So first of all, chapter 12, advocacy, that's recommendations 31 to 32. So the role of an advocate in social care context is to assist a disabled person to speak up for themselves, or if the disabled person is unable to do so, to communicate and represent the disabled person's needs and wishes. And the report identified a current ambiguity arising from sections 26 and 26A of the Children Act 1989 as to whether advocates should be provided during assessing and planning, or whether advocacy is limited to the making of complaints. And currently, parents and carers do not have any statutory right to advocacy support under the Children Act in relation to the assessment of their own needs or their child's needs. The only exception is they can have advocacy under the Care Act 2014 when their child is making the transition to the adult social care system. So a summary of the recommendations are set out in this slide. So the report sets out at paragraph 12.19 that advocacy should not be limited to the making of complaints, as one of the most important functions of advocacy is to avoid the need for complaints in the first place. And the report asserts that children who have the requisite decision-making ability should be able to opt out of that advocacy rather than an opt-in model, as disabled children who are most in need of advocacy are, by definition, those who may struggle to identify that they need an advocate or ask for one without help. And it also sets out that parents and carers should have that same right in relation to parent-carer assessments. And it's very important to note that the recommendation is that advocates should be independent of the local authority, so that there is no risk that the interests of the child and the advocate may conflict. If we could have the next slide, please. So chapter 13 looks at transition to adult social care. This recommendation is all about providing a statutory age at which transition planning from children's services to adult social care should start for disabled children. In the context of social care, this transition takes place at the age of 18, when the legal duties under the Children Act 1989 are replaced by the duties under the Care Act 2014. And under the current law, there's no set age at which the process of identifying children likely to have adult social care needs must start. Rather, it begins at the point the local authority judges it to be of significant benefit to the child. This quote that is on the left-hand side of the report is particularly hard-hitting about the consequences of the current issue. In consultation, the biggest single theme, which was identified as a problem by both local authorities and parents and carers, was that problems are caused as that transition process does not start early enough. And the recommendations are essentially that assessment of likely support needs should begin by the school year the child turns 14, which is usually year 9. Statutory guidance should confirm there's flexibility to start that earlier where it's appropriate. And the report asserts that alignment with the SEND legal framework and healthcare, where the age limit is also 14, is particularly important and should facilitate that holistic approach. And that's one of several recommendations that would bring disabled children's social care to be more aligned with the legal framework for determining educational support. Next slide, please. Thank you, Stephen. Next slide, please. So this is the final chapter I am covering, and this is the intersection between social care and healthcare recommendations 34 to 36. And the boundary between health and social care, as many of you will be familiar with, is not always clear at all. Whether care provided is classed as health or social care matters not just in terms of who provides the service, but also whether it is free or potentially chargeable. And for adults, the dividing line is set out in statute, and that's section 22(1) of the Care Act 2014. Referred to as the quality and quantity test. So the first recommendation is that legislation should set clearly that the existing dividing line between health and social care in the context of children's care, emulating that section 22. And the recommendation doesn't go further to include power to specify which services may or may not be provided, because it's felt that that is a political decision. The second recommendation is for co-authored statutory guidance, which would form part of the overall statutory guidance that's recommended in Chapter 2. And the report emphasises that the guidance shouldn't itself determine the obligations that are owed by NHS or local authorities. Rather, it's to help explain how those respective statutory obligations are to be discharged. And there should also be a role for parents, carers and disabled children to input. And very quickly, finally, the third recommendation here is to subvert the currently complicated route to the assessment of a disabled child's social care needs where they have been detained under the Mental Health Act 1983, which is currently not in one single legislative provision, which is currently creating a barrier to children being assessed in a timely fashion. And this proposal is simply that the interaction is made clearer and simpler, not for any change in policy. And Stephen, if I may, very finally, for those who are interested in a further discussion of this report, I have also written an article that's being published in the February edition of the Family Law Journal. So do keep an eye out for that, please. Thank you.
Thank you, Liz. That's really helpful, and we'll all look out for the article, I'm sure. We do have some questions that have been sent in, and we'll be answering those later. And there's already a point being made, and I'll just read it out. Local authorities already genuinely struggle to find advocates despite their best endeavours. What financial and other support is envisaged to ensure that this gap is filled at a national level? That's the sort of point that we will be covering in a moment. But first, we have the privilege of hearing from Mark Calway on recommendations 37 to 40. Mark is a family practitioner specialising in care proceedings, particularly non-accidental injury cases. He also sits as a recorder and often speaks with me at conferences for chat. But over to you, Mark.
Thank you very much, Stephen. Good morning, everybody, and we're on the last lap. Recommendations 37 to 40, covering paragraphs 15 to 17. Section 15, which is headed Identifying Needs in the Local Area and Securing Sufficient Services to Meet Those Needs, leads to the one recommendation which you see on the screen in front of you. Perhaps an obvious point, until you know what the need is within your area and who you need to assist, you'll not be able to provide the services to assist those disabled children. Consultation set out clearly that there was a differential in practice around the country, despite there being a legal duty under the 1970 Act for local authorities to hold a register of the disabled children within their area. That wasn't always, in fact, what was happening. Some other areas did utilise the joint strategic needs assessment approach, although that was found to be problematic because on occasion that wasn't including within that assessment social care needs. So that's led to that recommendation that in fact the 1970 duty to provide the register in fact be replaced wholesale with the duty upon the local authority to conduct a joint strategic needs assessment covering the social care needs of all disabled children within their area. Next slide, please. Recommendation 38 is in section 16 of the report, cooperation and joint working. Identifying a clear problem. You've got lots of different statutory authorities, different duties exercised by different public bodies relating to disabled children, so social care, health, SEND, etc. What doesn't always happen in practice is that one hand doesn't know what the other hand is doing, and there's no joint working. There is guidance in place. Social care services and the SEND system already has guidance to implement a role for a designated social care officer, DSCO in each local area. That's something that has been recommended by this report, emphasising, of course, that designated officer would need to be someone who had a senior role, that would be a standalone role, so it wouldn't be somebody who simply had other responsibilities and this being given to them on top of other responsibilities. One could see how that would work too well, but is an effective, certainly in my view, if it actually worked as recommended, likely to be a important recommendation, because joint working is often the key to getting the right services to the right children. Next slide, sorry, please. Thank you very much indeed. Recommendations both 39 and 40 are within section 17 of the report, which is headed remedies. Firstly, in relation to this perhaps rather Delphic recommendation, which sets out a hope rather than a specific recommendation, the report identifying that there were issues with resolving disputes where families weren't satisfied with provision, sets out the current different types of complaints procedures, the ombudsman, internal reviews, judicial review, perhaps in certain circumstances, raising matters with the SEND tribunal. The report took the view that this was really perhaps more of a political question than a strictly legal question, and in light of that, wasn't something they could make particular recommendations about, although the report, which I'd recommend you read, does set out the current different routes that families would have to make effective complaints. But the recommendation
Mark.
Thank you very much indeed. Is that's something which the government needs to look at, and of course the government, since this report came out in September, do have 6 months in which to respond. Next slide, please. Thank you. The last recommendation. This was a far more particular, pointed recommendation. noticing that an anomaly within the rules for the Sen Tribunal was that though the Sen Tribunal could, in the course of an appeal, using its case management powers, order that there be an assessment, a social care assessment, that wasn't a power that the Sen Tribunal had as a part at the end of the appeal using its remedial powers. So that recommendation there, that the regulations be changed to allow for that to happen. Thank you very much, Stephen. That's the end of my section.
Oh, that's fantastic. Thank you to everyone who's spoken. We've kept to time pretty much. Thank you for sending in the questions that you have sent in. The slides that you've seen will be sent out following the conference, and if you have questions that you would like to send in to be answered by people, then please do that. But we're now going to deal with a few questions that have been sent in. We will finish on time at midday, but Jim, I wonder whether you could help us with this question, please, that we've received. Is there more funding for the legal duty of local authorities to assess and meet the needs of disabled children? Thanks, Jim.
Thanks, Stephen. Well, the Law Commission was very clear that it does not have a role in making political decisions about funding. Its role is to simplify the law and to recommend ways of making the law more simple. Having said that, simple law can lead to cost savings. So the most obvious way in which I see that happening is, rather than having different local authority departments doing assessments, perhaps for education, health and care plans, for disability, children in need plans, you might see that being a holistic process where you end up with one report only, one assessment only. But in short, the answer is no. There's no more money being made available by the Law Commission, and it will be a political decision, and one that our political representatives will have to grapple with in the coming months.
I can well imagine the sensitivity of that issue for those who are lawyers or practitioners within local authorities. Jennifer, I wonder, could you deal with this question, please? Why do we need a statutory duty to assess when we already have the early help and family help assessment schemes?
Yes, thank you, Stephen. I wasn't able to get to that in my presentation, so I appreciate the chance to just speak about it a bit further.
Thanks.
The early help and family help schemes are actually not statutory services. They're policy initiatives by the government. And these are, as policy initiatives, are not actually expressly set out in statute. Now, local authorities are statutory bodies, but they can only exercise the powers that are conferred on them by statute. And so the Law Commission's view, in the report anyway, is that any goods or services or financial assistance that is provided by local authorities to disabled children or other children in need are likely to be provided under Section 17 of the Children Act. And therefore, the legal source of that power remains the same. So whether it's called a Section 17 assessment or an early help or a family help assessment, it needs to be an assessment of social care needs of a disabled child. And the recommendation to have that kind of an assessment, as recommended by the Law Commission, isn't meant to duplicate or replace early help or family help assessments, but it is meant to be something in which an early help or family help assessment could contribute. The early help or family help assessments are not, therefore, a way to circumvent the recommendation that there is a single express statutory duty to carry out an assessment. But any interaction about how early help and family help assessments would interact with this duty would have to be set out in the guidance. I hope that helps, Stephen.
Oh, it's really helpful. Thank you.
Thank you.
John, I wonder whether I could ask you to squeeze the universe into a ball, as T.S. Eliot might have put it, and help with the question that's been sent in. How effective have reforms been since the 1989 Children Act?
Oh, right. The reforms that have existed have largely been driven in education by the original act was 1993, then 1996 reenactment, and then the 2014 act, which have had a direct effect on children's social care. And the expansion of the tribunal's jurisdiction means that the tribunal is the only body which actually can independently assess social care in, of course, children and young adults cases. So that's become particularly important, and those have been the main reforms. But they have been largely accidental, not deliberate, because of the fact it's been realised that there's a interchange between social care, which educates and trains, to use section 21, subsection 5, and social care and education match. It's resulted in changes, which means that local authorities do work in some areas closer together and are held responsible for meeting needs, when previously the courts have been very reluctant to enforce duties to deliver. And under the Education Act, it's a mandatory duty. So it's not been a deliberate progression. It's been a step-by-step progression, largely driven to some extent, frankly, by the courts. So basically, the government's been supine because it costs them more money. So you have to ask the question now. The Chronically Sick and Disabled Persons Act is the equivalent of a 1906 de Dion Bulletin. Are they going to do anything about it? Because many of these recommendations, even if you don't give more money, will cost more money whether you like it or not. So either you're going to have implementation without funding or a reluctance to implement at all. I'm afraid that I'm a great liker of Greek drama or modern Irish drama, and both result in Cassandra taking the forefront. So I'm not optimistic.
Okay, thank you very much. There have been other questions that have been sent in. We were going to deal with 3. Should there be a statutory duty on the local authority to secure the provision in a child's social care plan? Also, whether what we think about the recommendation for a co-produced section within the statutory guidance that sets out the intersection.
You've muted, Stephen, sorry.
Sorry, I'm so sorry. We were going to deal with other questions as to whether there should be a statutory duty on the local authority to secure the provision in a child's social care plan, the recommendation for a co-produced section within the statutory guidance that sets out the intersection between social care and health, and also to consider the effectiveness of the designated social care officer. However, I think we've run up against time, as was probably inevitable on a 1-hour slot dealing with such a big issue. Those are questions that we could deal with by way of written replies when we send out the slides. Also, we will be sending out the slides, as I've said, fairly shortly after the conference. Can I thank everybody for the presentations, first of all, that have been given. They take an awful lot of work to prepare and to condense such a large amount of material into a 1-hour session. Can I thank the participants for joining this conference? We were up to just over 200 participants, and that is also a reflection of the considerable organisation that's been put into this conference by the 3 people that I mentioned at the outset: Jim, Hirschmann, Delphine Avondo, and Neve Jarvis. Thank you, and that completes the conference pretty much bang on time. Thank you.